Well, let's dive into it because it's a broad topic. The topic that we are discussing today is the law of, I guess, sex work in Canada. Some people have asked before why we cover criminal law on this immigration podcast. And the answer and how this podcast episode sort of came to be is I was reviewing a American criminal record, which stated that someone had a conviction for prostitution, and you have to determine what the Canadian equivalence is. And the law of sex work in Canada is extremely complicated. I remember I asked a few other lawyers saying, "Hey, what are your thoughts? Is prostitution or sex work legal?" And some of the answers I got back were, I think the actual act is, but everything associated with it is illegal. And a lot of people saying, I don't actually know. I thought it was legal, but then I see that there's a charter challenge right now challenging its illegality. So we have on today two lawyers with experience representing clients in this area, Connie Campbell, who has been on the show before, and Francis Mahon, who is a criminal defense attorney in Vancouver. Thank you both for coming on.
Is that actually how you pronounce your last name, Francis?
No, it's Mahon, but I
Yeah.
accept.
Okay, that's a few
Yeah.
guests in a row where I've gotten the
Yeah.
last name wrong.
Massacring last name.
Barely.
But I want to start with the an initial question that when it comes to these two terms, prostitution and sex work, I think Francis, you had mentioned that the term more commonly used now is sex work. Legally, is there a difference between the two terms?
There's no difference, and the criminal code doesn't use the term prostitution or sex work. They really focus on people who are either providing or buying sexual services for consideration. So the language in the criminal code is sexual services. The reason I brought it up is because, I try to be directed by our clients and communities in this. And for most people, sex work or sex workers is the preferred term. I do know there are some individuals who choose to use the word prostitution in relation to their own work. And of course, that's everybody can speak about themselves and their own work in whatever way they wish. But I would say the vast majority of people that at least I've interacted with prefer the term sex work and consider prostitution to be offensive.
Yeah. And sexual services then for consideration is how the law in Canada defines it. Sexual services for consideration to me, like sexual services almost seems broader than sex work. So what does sexual services include?
I think you've hit at the heart of what makes these laws really difficult to interpret on the face of how they're written in the criminal code. Uh, I think for anybody who's interested in this issue, at least how the government is approaching it, the government issued a position paper on not long after Bill C-36 was introduced in December 2014, which is a really brief explainer of at least how the government is approaching these issues. And in fact, they do say what they mean by sexual service. And the government defines that as a service that is sexual in nature and whose purpose is to sexually gratify the person who receives it. So that's obviously quite broad. And then the government also gives a list of examples that they would consider to be a sexual service for consideration. So I can get into some of those examples now, but it might be more helpful for me to do that in the course of your
Yeah. Well, actually, why don't we start with what are those examples?
Sure. So I just want to make it clear, too, that this is just what the government says. And I think we'll get, both Connie and I will get into our own anecdotal experience about whether or not these are actually being enforced on the ground, either in a criminal law or immigration law context. But what the government has said is sexual services for consideration is if a person pays for them, that would include sexual intercourse, masturbation, oral sex, lap dancing, which they define as sitting in a person's lap and simulating sexual intercourse. It would also include sadomasochistic activities, as long as those acts can be considered to be sexually stimulating or gratifying. So that is a list. It doesn't appear to me to be a closed list. I have not seen enforcement of the vast majority of that list.
And what is it illegal to pay for it or to provide or receive the consideration?
It's illegal to pay for it, which would be one form of consideration. Other forms of consideration would be providing somebody with illicit substances like drugs or alcohol in some circumstances. So and that actually is the main change of the law in 2014, is that previously sex work was not actually illegal under the criminal code, except in very defined circumstances. And now we have this split model where it's the people who are purchasing or offering consideration for those circumstances or for that sexual services whose activity is now criminalized. On the other side of things, individuals cannot be in public offering the sale of their own sexual services in some circumstances. So they can't do it next to a school or a playground and in some other places. But generally speaking, street-based sex work is still legal. And then the one thing that has not changed is that any purchase or sale of sexual services involving minors has been illegal for a long time and continues to be illegal. There's harsher penalties involved now if it involves minors.
So is it safe to say then that prior to 2014, there was a narrow list of where the provider of the sex services for consideration was criminalized? And then in 2014, they changed it so that it's the person who offers consideration, which again, that term means like payment or other benefit to the person providing the sex service, and really broadened what people can't offer consideration for.
I would say that so the constitutional challenge in Bedford in Canada, it really actually focused on whether or not sex workers can work indoors, because that was actually the main way in which sex workers were criminalized, was working out of their own spaces, be it an apartment or condo, or what sometimes is termed as a micro brothel. And
Or in
sex
the law as a body house, which I've always found incredibly dated and weird.
Right.
Body with a B-A-W-D-Y.
It's a
Yeah.
common body house too, isn't it?
Yeah. So, so the argument by the applicants in Bedford said that the inability to work indoors or to hire people like bodyguards or drivers, etc., that made their work significantly more dangerous than it would have been otherwise. So that was the basis on which the constitutional challenge was brought, and the basis upon which it was won, because the court found that the laws were either grossly disproportionate, arbitrary, or overbroad, which are principles of fundamental justice under Section 7 of the Charter.
That's really interesting.
And so what do you actually see in terms of on the ground who is getting charged?
Pretty much only people who are trying to purchase sexual services for minors, or people who are offering the sale of sexual services from minors. I'm actually, and I just want to make it clear that this is my own anecdotal experience, and just having stayed apprised of a lot of the main cases that have been going on. Most of them are involving minors, but not exclusively. So for larger establishments that offer sexual services, those have faced some enforcement, and that itself was the subject of a constitutional challenge in Ontario several years ago, which was actually successful.
Is that what you're seeing also, Connie?
I don't do a lot of the direct criminal law enforcement, so I see more of the immigration side of things, and I can say what is still going on. So to back up, there is a prohibition on anyone without permanent residence or citizenship engaging in the sex industry broadly, as it's termed, at the bottom of every work permit or open work permit. We're all familiar with it being stamped as not valid for work in strip clubs, other, sorry, I don't have the text in front of me,
Yeah.
unfortunately, but there's
I can
Yeah.
a
read it.
list
It's, yeah,
of, yeah.
you're not allowed to work for an employer who on a regular basis offers striptease, erotic dance, escort services, or erotic massage.
Yeah, exactly. So you end up with a lot of enforcement, particularly bylaw enforcement against places like erotic massage parlors. Um, there's not a lot of enforcement against um, places that offer striptease. And in my limited knowledge, um, there's not a lot of enforcement other than by the liquor control boards or the provincial liquor control boards against strip clubs. Um, that said, if somebody, and I have had clients targeted under these provisions for offering sexual services out of their own homes, which to my mind doesn't actually run afoul of the provision. And I was able to convince CBSA to back off in at least one case, though we were like on the eve of an admissibility hearing.
Oh, that's
So
interesting because I've heard that discussed, whether self-employment and the provision of sexual services violates the immigration restrictions.
So let me get this straight. In the criminal context, they don't tend to be prosecuting those people that are offering services in their own home. But of course, CBSA, even though it is within the letter of the law to prosecute, is that correct?
from a criminal law standpoint, it's not illegal for an individual sex worker or a coalition of sex workers to be working indoors to provide their services. That's absolutely clear under the law.
Okay.
When there's an element of what the police or government would consider to be exploitation, so others profiting off of their work, that's what the criminal code
I
says.
see.
There does seem to be some conflict between the immigration law and the criminal law.
I see.
But both
Imagine that.
objectives, I guess, is how the government would try to marry those two things. But I
Okay.
think speaking maybe more to the immigration policy that justifies the inclusion of that in work permits.
Okay. So in the criminal context, it sounds like that policy has rationalized itself to some extent by prohibiting something that is going to enable exploitation, but not prohibiting things that are going to enable protection.
That's right, and that was the legislative response to the Bedford decision. It was the Bill C-36, which is what led to our new criminal laws, was met with a lot of dismay by sex workers and sex work advocacy organizations because, in their view and in my view, it still makes it extremely difficult for individual sex workers or sex workers working together to work safely. And that's because the person purchasing those services still runs afoul of the law. So it's very difficult to envision a scenario in which one person isn't doing anything illegal, but the person they're working directly with is
Totally.
illegal. So that's, I think, to me, is where the law is strange and ineffective in actually achieving its objectives, which is to really
That
to
totally makes sense.
deter people from engaging in sex work very broadly. Like that's the clear policy goal of the new laws.
So how do
Right.
the police, I mean, from what I understand, they aren't charging, like how would they even catch people? Like, is it often the case that the police would pose as sex workers to basically entrap people who want to pay for sexual services?
Yes, I'll get into that in a minute. I can say that the Vancouver police, at least nominally, have a policy of non-enforcement within Vancouver for individual sex workers or indoor sex work. As you said, it's extremely difficult for the police to even know if people are purchasing sexual services if that's happening indoors. Like I said earlier, the enforcement tends to be focused on minors, and there was a couple of years ago a sting operation where police were posing as potential clients of an establishment that they believed was using minors. And so through that work, they did lay criminal charges against the people who were in charge of that operation. So yes, they were kind of posing and in doing that, but that was mostly online, not in person, which I think would be terrible.
Yeah, but at least they're using the resources to actually target those who are causing true harm, like where there is exploitation and not just in the run-of-the-mill type of scenario.
Sure. That said, and Connie mentioned this, that there is quite a bit of use of bylaws. And I would say also large police presence outside of establishments that they know are believed to be being used for sex work. So although they're not enforcing, I've heard anecdotally from clients that they will have a place where they're working with other sex workers together as a cooperative endeavor, but sitting outside will be for police cars, which is obviously a deterrent for them and for any potential clients. So, and then by enforcement, that would be, you know, ticketing somebody for loitering or littering or walking or that sort of thing. And so that's the main deterrent for street-based sex workers. So again, they're not being charged, but there is a deterrent being used through various bylaws that exist, at least in the city of Vancouver. I've also assisted people in Saskatchewan and Alberta and on the East Coast. And again, anecdotally, I've heard stories about that happening.
Wow. Now, going back to the immigration context, do you know, Connie, like that condition or that remark? No, it is actually a condition on all temporary documents that just showed up out of nowhere at some point, like about a year and a half ago, wasn't it? Do
The
you?
work permit condition?
No, that goes
Oh,
back to
that's been a while.
2013.
Was
And
it
it's
really?
actually
Oh my God.
codified in the regulations.
Okay.
That
Wow.
was a Harper era
Of course it
change
was. Yeah.
to there was a big blow up in the kind of the preceding administration around the issuance of what were then labor market opinion
Right.
assessments for
Exotic dancers.
exotic
Well,
dancers.
there
I
used to be a
remember
There was
that.
category, a specific
exactly.
stripper visa category was what it was called.
Well,
Yeah.
that wasn't what I was called. It was the exotic
Yeah.
dancer visa, but that's what you might have called it.
No, but that were at least in the media with Judy Scrow.
Yeah.
Anyway, this is yeah.
Yeah.
Definitely. No, that was the case. There was a concern, even amongst some Canadian-based sex workers and their allies and around the public generally, and I think this was a bit of fear-mongering on all sides, that women were being, quote unquote, imported from particularly Eastern Europe, who were willing to go beyond the standard of behavior in strip clubs in most of the Toronto region, and were undercutting working standards and potentially victims of human trafficking. Whether or not that was the case, the conservative administrations that came in after, in the name of fighting supposed human trafficking, introduced these elements that restrict the freedom of all temporary residents of Canada, not even from working in, quote unquote, the sex industry generally, but from even working as a bartender, DJ, doorman, anything
Security
to do
guard.
security guard. You cannot work for a place an institution that offers striptease as a temporary resident in any capacity, not just as a dancer.
For sure.
Well, yeah, I remember about a decade ago, and I'm curious to know then whether this would be considered a sexual service. We were approached, actually referred from another lawyer who had a client that was a tech company that was going to hire an American porn star to come to Canada. They were going to attach to the person all these chips or monitoring devices. That person would then have sex with a Canadian. The monitoring chips would track what was going on, and it would be used to create a sex scene in a video game. and they were trying to determine, do the work permit provisions now prohibit that? And I'm curious whether something like that would be prohibited criminally in Canada as a sexual service for consideration, which then sort of dovetails into like one of my questions that I'd written to you both about, which is the whole porn industry
Mm.
and whether that falls into this.
To be honest, I actually don't know the answer to that question because it's not addressed by this position paper, and that's specifically whether or not pornography would fall under these laws. So I am personally not aware of a single person or case who's been prosecuted in Canada for either appearing in porn or providing that. I mean, maybe strictly speaking. So another thing that's made illegal is advertising the sale of sexual services. So an individual sex work can advertise their own sales, but people cannot do that on their behalf. So
Interesting.
within that, I don't know, but I'm also not aware of any cases that have actually prosecuted somebody for advertising somebody else's services, again, except in the context of minors. I could be wrong about that, but as far as I can recall, that has not happened. That said, there has been significant criminalization in the States of websites where sex work is listed. And often in the course of that, people will be making sexual videos to give, potential clients an overview of what they might offer. So that there has been some enforcement focus in the States, which has led to some consequences for Canadians that I've assisted. But again, I haven't really seen anything specifically within the porn industry being criminalized.
I just find when we start talking about this, I realize how incredibly uptight and taboo we are about certain conversations, and that certain things are just widely accepted as existing. And even like this kind of, oh, we're going to keep this on the books, but we're just not going to prosecute. But that especially when there's such a disjointed approach at the criminal level and at the immigration level to how we deal with things. I wanted to hear a bit more from Connie about, something that would not lead to prosecution at the criminal level, leading to enforcement at the immigration level. I mean, I've seen CBSA like going hard after somebody who was a security guard at a club, and then drawing in all sorts of other kind of allegations and organized criminality when they were like truly a security guard, and ultimately failing, but making somebody's life like quite miserable for a prolonged period of time with truly like zero evidence against them. But I had never really turned my mind to the fact that this is really the consequence of like very precocious regulation in this sector and a non-purposive approach to dealing with this regulation.
Yeah, I'd say broadly, like there was a recent constitutional challenge to the criminal provisions, and this is going to be a bit of a detour, but one of the
Please.
reasons that
I love a Connie detour.
And it's something Francis brought up earlier, but one of the primary legislative purposes of the post-Bedford criminal provisions was to deter people from engaging in sex work. And one of the problems with the sex work advocates and their allies who worked as interveners, and I believe had party standing in the challenge in Ontario, we're still framing it around women's autonomy and a kind of optimistic reading of the post-Bedford provisions, saying that it was about allowing women to do sex work safely, when that's not actually the case. And the Ontario Court of Appeal came down really hard on them for it, saying, and on the trial level judge who found this, who agreed with this interpretation of the legislative intent, but that it was an ideological law. The law was to push people out of sex work because there's a contingent of people who believe that this work is not work. And it comes down to an ideological dispute, not really a legal one. And they wrote the laws, and it's been a failure on the part of the Canadian, or of people who believe otherwise, to change those laws. And I think that there is a constituency in Canada that does believe in that, and that does believe in people, in sex workers' autonomy and ability to choose to do this work and to profit off of this work, to the extent that they're able to. But there's an enormous squeamishness or precociousness about actually saying that loudly in any public forum, and it's not seen as a winning political issue.
Let
So
me
these
up with an interesting anecdote. So when Bedford was before the Supreme Court of Canada, I believe it was the CBC or the Globe and Mail, actually did a wide-ranging poll across Canada, and the majority of people were actually in favor of decriminalizing sex work, which is very interesting because that was actually data to back up what we were hearing anecdotally from the public. Now, granted, that was well over a decade ago, and I don't know how attitudes would have shifted now that there's a growing awareness of sex trafficking and human trafficking more generally, or at least how those terms are presented to the public. But I just wanted to pop that out there because I was fascinated with that at the time, and it actually was kind of vindicating and validating for our.
So can you touch on why so if the police aren't enforcing it, some people may say, well, if they're not enforcing the law, why is it difficult? Why does the law make being a sex worker difficult? So what are the obstacles that sex workers face given the non-enforcement of the law?
I'm going to answer in a very plain sense, which is, for me, part of it is that it's for the same reason that people don't like to say, I watch porn. Like, I think people just have hangups, right? Like, and I think for a lot of people, it's because they don't want, like, people have a squeamishness to some extent because they don't know where that pornography is coming from. Is it ethical? Is it unethical? But it's also because of all this like Judeo-Christian programming about like, I'm not supposed to admit that I have these feelings, that I have these desires. And so it's very loaded. But I think that the problem is it's like making this illegal, making the procurement illegal, making, like we can't actually shame the person who's offering it because we all know. So I think it's a very complex issue. And in order to unpack the legal stuff about it, I think to go at the taboo itself is the starting point.
But does it go beyond that into like ability to get bank accounts, ability to rent a place?
Yes, absolutely. So
for sure.
Even setting aside criminal law, lots of condo boards, for example, will have prohibitions against sex work. And so if they become aware that somebody is offering sex work out of a condo in a building, either if they're a renter or an owner, there will often be work to stop that. So it happens much more on like a small scale level. In terms of police non-enforcement or non-prosecution, that's simply because both the police and the Crown have really wide discretion about whether or not to enforce things, either because it's not in the public interest or because they just don't think they're going to get a conviction out of it.
But on that point, all this thing is operating under the threat of enforcement. It's, can you actually count on this promise? Do the people who are procuring services, who are knowingly breaking the law, do they feel comfortable sharing their identities with the people from whom they're purchasing sexual services? Are the ability to screen clients is then implicated?
If somebody refuses to rent to me, can I bring a human rights complaint on the basis of, failure to offer services reasonably available? Will I be kind of treated in a sort of shamey kind of a way when I appear before that tribunal? So it is sort of part of that bigger picture thing. And like the legalization piece has to fit in, because if there's still ambiguity about whether or not that service can be offered legally, then your standing is implicated.
Yeah. And that's the heart of the constitutional challenge that happened in Ontario. So that was brought by the Canadian sex work law reform and then a bunch of individual sex workers. And that was exactly the focus of their challenge. And as Connie mentioned, the court basically found that there was very conflicting evidence about whether or not sex work was, a good thing or a bad thing.
So funny.
Yeah, so, but ultimately found that the purpose of the law was very clear about eradicating sex work, and thus the provisions themselves were not overbroad or grossly disproportionate. That decision is now on appeal, but is nowhere near starting from what I understand.
Wow.
Going back to your earlier question, Dana, about kind of the immigration enforcement of things that are not criminally enforced, the broadest impact of the migrant sex work prohibitions that I can see is that it forces women who are doing this vocationally to just basically fall out of status. My understanding is that most of the women who are not permanent residents or citizens of Canada, or people generally, but again, it is mostly women, um, are here on lapsed visitor visas, lapsed student visas, um, some of whom go back and forth to their home country, many of whom stay here and who would like to be able to go to leave and return freely, but can't because they can't get a real work permit for the work that they're doing. They're able to support themselves. Many of them have a very solid financial stability. They enjoy their work. They found a way to do it in a manner that feels safe for them, but they're not able to regularize their status on that basis. So you end up having to file often humanitarian and compassionate
Yeah, TRPs.
applications where
Yeah.
you're admitting not only to work outside of their status, but work that is kind of double criminalized and
Yeah, for
seen,
sure.
and that most people don't want to admit to for the reasons of stigma and everything else, that it's unclear how IRCC is going to look at it if you say, well, I have a lot of financial stability and it comes from doing sex work outside of the regulatory provisions. And you're admitting to not just violation of ultimately it is just a term of your work permit, but because it's explicitly prohibited under the regulations, it feels a lot more serious.
Yeah. But also
And
all of your clients are breaking the law. And so again, it feels kind of like, if they're paying you, it's not a very stable business model because you're relying on the prosecutorial discretion of the Crown to not eliminate or eradicate your entire business line of business. It's very
Yeah,
confusing.
like one other issue that Connie and I were seeing quite a bit, and I'll let Connie speak to whether or not that's still happening, is that migrant sex workers would go to the police complaining of violence or being robbed or simply just not being paid. The police accepting that complaint, not really investigating it, but contacting CBSA to know that these micro
That's
brothels
so awful.
involving migrant sex workers. So I just don't know, because I'm not working in that space anymore, whether or not that's still continuing. We were certainly seeing it.
I haven't seen that explicitly lately, though I'm not saying it hasn't happened, but that shows exactly sort of the kind of insanity of these provisions that are meant to quote unquote protect women from the dangers of human trafficking. And what ends up happening
Yeah,
in their riding in on a white horse, the police and CBSA end up deporting people,
for sure.
Yeah, I mean, that
pushing them
happens
across
across the board with
borders.
preventing employer abuse.
Yeah,
I know.
I want
I
to
have
go
to say
back.
that I got out of the trafficking space. This was really the focus of my career at the start of my profession. We created a coalition, the Anti-Trafficking Coalition. We all pie in the sky about and you know a group of us made the submissions that led to the creation of the VTIP TRP. Actually, with funding from the government, we were like so optimistic. But the people that ended up that were coming in as trafficking, like even when there was the work permit ability at that time, those were not like the people that were coming in as actual like exploited sex workers were not getting work permits. Like that, so it's like this conflation, this idea that the work permit, the legalization is going to give rise to the exploitation and to create this underground marketplace. I feel like that's always misunderstood. Like that exists already, and going after true exploitation is not created by legalization. I find that sort of challenging. Anyways, I just found that there was so much emphasis on enforcement at that time that it provided very little in the way of alleviation, and so much more in the area of enforcement that it was all about collaboration.
And what I've seen in some of those cases in interview, like I've read interview transcripts where if somebody's being asked if they're doing sex work or entering Canada to do sex work or whatever the case might be, and if they say they're doing it of their own accord, that is with autonomy, they're barred and deported. And if they say that they're
On
exploited,
what
then they're
ground?
pushed into violation of their work permit conditions, or they're pushed into an admissibility proceedings at least.
Yeah,
But if
So
they say
going,
they're exploited, they're then pushed into the VTIP program.
yeah.
But in those cases, you get a, 1 year, 2 year work permit, and then you're sent on your way if you can't
Exactly. Now you're
file some
recovered.
other
Are you
application.
recovered yet? Like, are you
Yeah.
better now? Okay, so now you can
yeah.
return to the country where you were exploited and trafficked. It's very much this kind of victim mentality, having to prove how badly victimized you were, and that if you weren't truly bound and gagged, then maybe it wasn't really coercion, even though the policy that was the way that it was at the time. And I understand that it's not being interpreted quite in that way now, but I kind of got burnt out.
So Connie,
What
going back to the work perm, like people who are being turned back because they say that they want to engage in sex work. Oh, sorry, when you went on your own accord, do you mean like voluntarily for an employer or in self-employment?
There's usually it's a suspicion that somebody is attempting to enter um, for the purposes of engaging in work on a temporary
Yeah, because
visa.
I think you mentioned earlier that you had an incident where CBSA was pursuing someone who was working as a self-employed sex worker and that CBSA did back down. And I've had people email me asking me, oh, I want to do an OnlyFans while I'm on my work permit. Can I? And I say, well, you might be at risk of being a test case. And without, don't take legal advice from this podcast sort of thing. But like, what is your take on that? Because I think you said you've seen CBSA back down on whether that set of self-employed sex work does reach that provision.
What's OnlyFans?
Oh, Deanna.
It's what I have to go and do some research.
Yeah, you
Clearly.
can go to OnlyFans after this. But yeah,
Okay.
so yeah, Connie, back to the question.
I think it's too hard to say exactly. I think, like you said, you put yourself at risk of enforcement, and there aren't clear rulings on that question. On
Yeah.
its face, though, you're an independent contractor if you're an OnlyFans producer. At most, you're using a platform to create online video content. Um, if you otherwise have status in the country, it's very difficult to see and have work authorization. It's very difficult to see how that runs afoul of the prohibition. But I wouldn't put it past CBSA
I
trying.
see.
And the case I was talking about, it was quote unquote full service sex work out of a private residence
Hmm.
um, that came to police attention because of a dispute with a neighbor.
Oh, goodness.
The issue um, that I was talking about earlier, though, is people showing up, um, usually at the airport, trying to enter as a visitor and getting turned around on kind of standard. Um, you're actually coming into work. You're coming here not with intent to visit, but with intent to breach your conditions as a visitor and engage in any kind of work. And in
And that's
those
based on
cases,
searching of their bags?
often, yeah. Oh, you're coming in with too much lingerie. You don't have a credible reception. You're set up in a hotel that was booked by a boyfriend who CBSA suspects is a manager of some kind.
Wow.
Um, that kind of thing happens quite frequently, and I see that more often in duty counsel. So because these women are often detained overnight pending a flight back to, in Vancouver, at least it's East Asia generally.
Wow.
And the reverse is true too. I've advised a lot of sex workers who have traveled to the US who are turned around and found inadmissible to the US, usually just for a year. But it's the same thing. It's getting their bags searched, or the border officials in the US actually going online and finding out that they're traveling to the US. Specifically, it's usually known as like a tour. That's the colloquial term.
Oh, wow.
So sex workers who are here, who are quite popular and well-known online, will announce that they're traveling to the US and have agreements with people. And so the US border officials will become aware of that and then turn people around. And then, they have this stigma associated with them that would also inhibit travel to other places in the world.
And
the
are they
US
dealing
too,
with these, Connie, as like failing to abide the conditions of their permit? Or are they dealing with these as organized criminality?
in a couple of cases, I've seen organized criminality raise,
Oh my God,
but
that's
only very
brutal.
rarely.
Okay.
Generally, and this is where, again, if you paint yourself as a victim and say, oh, I was
Oh
forced
my
into this, then
God.
you can come in on a temporary visa. And if you don't, then you're a member of the group that
Oh
quote unquote
my
trafficked you. So
God.
you self-trafficked to Canada,
So
with the intent
you're
of working.
victimizing yourself in order to avoid a lifetime ban and basically a global worldwide ban from travel.
Yeah, the US
That's
immigration is also
wild.
tricky because in the US, like Steve was saying, in most places, it is a crime, and it's also a crime of quote unquote moral turpitude, which leads to criminal inadmissibility to the states, requiring a visa waiver. And
Oh my God.
I,
I just want to slow that down for a second, which is that the reason we're saying this is that organized criminality, unlike just a regular work permit violation, is something you cannot get it leads to a deportation order, a lifetime ban, no humanitarian compassionate relief for life, no ability to obtain a TRP, and probably all other countries with similar immigration systems would look very poorly on somebody who had been found inadmissible for organized criminality. So you're better off saying I was victimized. Can I please have a That's really wild. It's so backward.
Can I ask a question? This is
Yeah.
around my own ignorance, but you had mentioned the VTIP program. Can you explain what that is and whether or not it still exists?
It still exists, but again, it was always very bizarre because there's a TRP. A TRP is something that you can get if you're ineligible or admissible for any reason for a temporary admission. And so this can be issued for any length of time. It could be issued for 1 day or for 5 years, theoretically. But if it's 6 months or longer, you can get an open permit. So they like to keep them short because if it's longer, you can get a work permit. And also, if you get them, they're not supposed to unreasonably deny extensions. And if you keep them for long enough, you could qualify for permanent residency, right? So they don't like to give them out very often. But weirdly, when they developed the VTIP TRP, they were like, if you can establish that you are a victim of trafficking, the V is just inserted in front of the TRP, victim, right? If you are a victim, then you can get a worse TRP than just a regular TRP. This one means you're going to cooperate with CBSA and the RCMP. You're going to be a witness in a prosecution. And now we'll give you a short one that maybe if you continue to be useful to the prosecution, we will renew. And so it's kind of like, or else you could just not use the word trafficking and say, can I just plain old have a TRP, which is kind of the approach that I've always taken. I
Yeah, although
don't.
the processing times now for the two types of TRPs are very, very different.
Yeah, sort of, but like sometimes in a compelling TRP application. Yeah, I mean, you're probably right, but anyways, I've always had a bit of an allergic reaction to that policy.
I'm still trying to wrap my head around how broad payment for sexual services is, especially because, like, like we
What one
often talk
person
about,
considers sex, the another
yeah, like
person considers punishment.
like,
Yeah.
is it, like using the hypothetical of whether it would be misrep to not disclose this, assuming that like it was a crime in the jurisdiction where it occurred as well. You mentioned lap dances as being in this government document of what constitutes paying for sexual services. Uh, would you tell someone who had gotten a lap dance that they had paid or that they had breached the criminal code?
Yeah, if somebody was asking my legal advice on that, and I've been retained many, many times by both people wishing to provide those services or accessing those services, and my advice is always like, yeah, under the strict interpretation of the criminal code, it is illegal. Whether or not the police are going to actually enforce that is a different question.
Yeah, I get consulted a lot by people who have extreme anxiety and are afraid that they have committed every sort of misrepresentation by not disclosing potential act, like committing criminal offenses. And often these kind of shame-based criminal offenses arise.
I mean, paying for a lap, I don't know if it's a crime abroad, but like, I think that's one of those that would shock a lot of people. The other one, and I know, Deanna, you don't know what this will mean, but like being a videographer for OnlyFans. If someone said that they wanted to be the person who films, not the OnlyFans star, but the person who's doing the filming,
Or
would
what if
you
they
say
paid
that?
because they have a foot fetish and they want somebody to
Well,
come
no,
over
they aren't
and
paying the
like
video. I mean, the videographer, that's a whole
is
separate topic of whether
totally.
paying OnlyFans, like being a subscriber to OnlyFans. Would that also, like in a strict reading of the criminal code, subscribing to someone's OnlyFans account, or the videographer who's getting a material benefit, assuming they do it for consideration? Like, would both of those things under a strict reading of the code also constitute
You have to get into their head,
sex
though.
work?
You have to see whether it's for the purposes of sexual
Right,
gratification. And in the
right.
cases of somebody being hired as a videographer, it's generally not. The line that gets very blurry is personalized content that you can acquire through OnlyFans. Um, the fact that you are like camming or chat based stuff. OnlyFans isn't that new. It's kind of a hybrid of
Yeah, it's a,
webcamming, phone sex,
But couldn't
and
that be living off the avails?
pornography. But again, that's the tricky thing is does that constitute sexual services, or is it more like pornography, which has never been criminalized? It might have been criminalized at some point in Canada under the obscenity laws and the importation stuff, but it's not explicitly set out, and that is the blurry line. I think that OnlyFans is actually a pretty good example of where the criminalization of procurement starts to fall apart. And again, as Francis said, our understanding is that there hasn't been any kind of enforcement against that. But it's very hard to provide appropriate legal advice around that
yeah.
kind of
And I mean, in the
I'll
immigration
say.
context, it would just be whether it's equivalent, not like, yeah, it's a, in fact, I would argue CBSA would often take the strictest approach in interpreting a statute.
Well, it's kind of like this. I don't know if it still is, but I remember in law school when we looked up the silliest offense, and there was like frightening the queen. Some of these things, is it what?
Witchcraft, let's not forget.
Okay,
Okay.
yeah, like these silly things that are still on the books, where it's like, things that are so commonly done and accepted as being part of regular society and yet still illegal. Like what does that do to our society? Because it still creates a baseline for what is acceptable.
Sure. I think I just want to get back to the example of the person who's actually like videographing. I don't know what the word is there. So one exception, I think it's an exception to an exception within the criminal code, is that if I'm a sex worker and I'm hiring somebody to help me, as long as that person is charging me what would be the going market rate, that's not actually illegal.
I
And
see.
using
Oh,
a
okay.
personal example, like I am a lawyer who provides advice regularly to sex workers. It's exactly the same thing. Like
Right.
as long as I'm not charging them, say, like 3 or 4 times as much as I would normally charge somebody seeking my legal advice, there's nothing inherently exploitative about that. And so that's why it's not considered to be a material benefit in the same way that somebody else who's, you know, running a large brothel or something like that would be criminalized in the same way.
Right. So again, going to Steve's point that there is some context within the criminal context, but always when you're looking at it in the immigration context, it's given the strictest possible interpretation, and there's no opportunity for an actual hearing, and the standard of proof is so much lower. So it's like the criminal context, it's behind, and then in the immigration context, it's even further. So
can I ask a question? So I know the IRPA, it has objectives set out at the front of it. How would that play into the way it's being enforced on the ground? I'm just personally curious about whether the three of you have an opinion on that, because the criminal code obviously has a very distinct and direct purpose, as does Bill C-36. But how would the objectives of IRPA perhaps lead to this over enforcement or really a strict interpretation?
the one that they love the most is maintaining the integrity of the
Yeah, it's just
immigration
thinking the same
system.
thing.
So we're always saying, well, but also for protection and for, so that there's ones that we love as advocates, but the one that we hear over and over again is maintaining the security of the Canadian public. I can't remember which one it is.
The
And
protection of public health
that,
and safety, and to maintain the security of Canadian society. So that's the
that's the one that they
denying
love. Yeah.
Canadian territory to dangerous organized criminals and human traffickers.
The dangerous, and again, like, I'm not trying to make trite the objective of that, but we clearly come at this from very different angles. I think there are things that I, as a Canadian, I'm concerned about, and other things that I think are grossly overprotected, to the point of actually being highly, highly punitive to the protection of safety.
Right. Yeah, I
And
agree
not at
with
all.
you about that. Like, there's no question that there is like quite a lot of exploitation and what would be like actually sex trafficking. But
For sure.
I look at it, and Connie and I, you and I have talked about this many times, but it's like illegal labor trafficking really at the heart of it, right? And so like, what is the difference between you know, a farm here in British Columbia hiring migrant workers and like severely exploiting their labor, and somebody doing that same thing in the context of sexual services? Like, that's the harm that's
For
caused.
sure.
That's the organized criminality, in my opinion.
Right.
As opposed to somebody simply traveling here, working out of a massage parlor and earning the same, you know, wages that they may charge themselves.
Yeah. Well, this was honestly the challenge in the back in the day when I was doing the anti-trafficking work, is that there was a very large divide within the anti-trafficking advocacy network as it existed at that time. There were those who were very much in favor of an abolitionist approach, and those who were
But that
much
still
more.
exists.
I know.
Yeah.
And it creates great rifts, sometimes on faith-based lines, sometimes on others, but like, so I mean, it did get very divisive, but I think that really, from my perspective, it needs to be about like a purposive approach. Like, I don't, for me, it's about how to truly look for safety and health and security and all those things that are actually stated in the act. But to me, prohibition just for prohibition's sake has never been the way to that. But I just don't think it's truly being looked at it from a purposive standpoint.
I think that
Yeah.
again, though, this comes to the ideological divide. If you believe that sex work is, and that's where the term, from going back to your very first question, see, that's where like prostitution as a term and why people think it's offensive is that it kind of inherently says that you are debasing yourself by engaging in sex work. And if you believe that it is inherently exploitive to be selling sexual services, anyone who is touching that is rightly being criminalized. And that's why I think all of these things come down to policy disputes a lot more than they do to something that you can get at through charter challenges, unfortunately, post Bedford, is that it's written into the act that Canada has taken an abolitionist stance, and that's the policy that needs to change. Is
Right, exactly.
they're saying, well, we won't criminalize the providers, but everything in the circle around it, other than these exceptions to exceptions that Francis took us through, that is, carved out not for the purposes of allowing that to happen, but just to not heap punishment on people that are already seen as victims, rather than acknowledging that this has always been a part of societies across the world
Right.
and that it's probably going to keep happening. And the issue is, do we allow it to happen out in the open where there can be more scrutiny of cases of exploitation and people who are being victimized feel comfortable coming forwards to law enforcement or other organizations? Or do we have a system where everyone is scared of the police and scared of what will happen, whether they'll be deported or their clients will be prosecuted or whatever? That's the system we've built. And like you're saying, it's not on just a policy measure. I think it's wrong-headed. I think if
Yeah.
you're trying to stamp out sex work and you're trying to,
Never gonna happen. That's the other thing. It's just simply never going to be successful. There's
Yeah, it's never. It's like trying to eliminate disease, it's
Well,
like, and I'm
so
not trying to compare disease to sex work.
No,
I'm just saying, like,
it's just not
things
something
cannot,
that
like, it's just not
everybody
it's not a reality. Like, it's being like, yeah,
so
we
I'm trying to
strictest punishment in the criminal code for murder, life in prison, right?
yeah,
And murder still happens.
yeah,
So,
yeah,
thinking about a deterrent approach through immigration or criminal law, like in my opinion, and the opinion of many, many legal scholars who are much smarter than me, it's just completely
yeah,
ineffective.
yeah. It's like making
yeah.
people stop having hunger. Like, it's just like, it is a fact of life.
Totally. And I liked how you, Deanna, like framed it as the shame-based approach, because I think that's really true. And the numbers of people who are purchasing sexual services is vast. And probably
Growing.
people, and I'm just speculating here, of course, not going to name names, but a lot of the people who would be, in public, taking an abolitionist approach are very likely some of the same people who are engaging with these services, because this would be really unlikely not to. I'll just tell a very quick anecdote, which is before Bill C-36 was passed, I was invited to give witness evidence before the Senate. And I was with Terry Jean Bedford, who is one of the three applicants in her case. And she got quite upset, rightfully so, during that Senate hearing, because she was only given 5 or 6 minutes or whatever to speak, and she was not given any more time. And she started threatening to name names.
Oh
Like
my
the Epstein
goodness.
And
list.
then, it
Yeah.
got very, like, she was told she was going to get escorted out, and she was. And it was just very interesting. And, I'd been a lawyer for about 3 weeks.
Too
Oh
bad
my
she
goodness.
Anyway,
too
you can
bad
just
she
search
threatened instead of
online.
just launching in. That would have been something.
Oh my
Totally.
goodness.
And,
Like the Epstein list.
at the time I was, and I still am, like, very proud of Terry Jean for always being a very public facing voice that calls out exactly what you said, Deanna. Like, this is a shame-based approach. There's nothing to be ashamed of. And people are simply lying when they say that this should be eradicated, because that certainly wasn't her experience in actually working with these people.
Oh my God,
No,
that would just be
and
so mind-bending. Can you imagine?
yeah.
Absolutely. Yeah.
Just in looking, I want to ask my last question, which was the question that I had asked Connie this on Signal, and they said JFC, and the only reason I don't say it is I don't know what swearing would do to Apple podcast requirements. You have to have me on this episode, which
You can
is
start
okay.
on
So
Sorry.
if I want to procure sex, that's a crime. But if I film it, does that make it legal? Because then it's just porn. And I don't understand, like, the question's a bit facetious, but I really have a hard time trying to reconcile how that's criminalized, but OnlyFans or paying for OnlyFans isn't, and the idea of trying to stamp out sex work, yet at the same time, I think the largest internet company in Canada is Pornhub. So, like, has there been an explanation for why one is legal, one is not? Like,
I
why is
think
porn legal and sex work not?
I think it comes down to exactly what we're talking about, is that pornography puts you at a distance from the kind of mode of production, and it, on the letter of the law, the people involved in the making of sexually explicit video content are generally not doing it for their own or for the participants' own sexual gratification. It's for the sexual gratification of strangers who are going to buy and watch this, or in this case, not, or in the case of Pornhub, not buy and watch. But there's interesting debates within the sex worker community between people who only do pornography and whether that makes you a sex worker or not, or whether that brings you into the community of people who do sex work. And there's, in some cases, discrimination on the side of people who say, oh, well, I do porn, but I don't do full service work because that's beneath me or whatever. I think those lines, my understanding, I'm not, directly in these communities. My understanding is those lines are blurring a lot, and there's a lot more kind of solidarity and pride and less kind of lateral violence between these communities. But the lines are arbitrary, and you're right to point it out. But it comes down to everything that Deanna and Francis have been saying, that these lines are purely based around the shame and stigma attached to the work, and it's always been seen as slightly less stigmatizing to do porn because you're doing it as a performance rather than engaging in the work of quote unquote selling your body, which obviously some people see porn as running afoul of that. The people are kind of on the far abolitionist wing, and then there's people who apply these kind of arbitrary moral gradations to different levels of sex work, whether you're doing online video, personalized online video, versus this more anonymous porn, or kind of mass market or larger audience porn, and then on and on and on down the line to full service in-person sex work. The distinctions are completely arbitrary. It's all about ultimately sexual gratification with a heavily gendered component that we haven't really gotten into, but that's a big part of it. And there's no way around the fact that these laws don't really hang together when you start to scratch at them. And that's why we have a situation where most of the laws aren't being enforced, because everyone recognizes the problems it would cause societally.
Yeah. You said gendered, but also misogynistic, anti-trans, like there's all sorts of other things that would need to be unpacked. But I think what's also very important is that it's not the privileging of, or the what makes one perhaps an offense and the other not. It's not based on one being inherently safer than the other. So it's not there's no specific qualitative difference, really, because as the whole Pornhub scandal showed, one is not by its very nature safe, because there can still be exploitation behind the scenes.
Yeah, of course. I'll just point out too that getting to the gender-based approach, like the explicit goal as set out in the preamble to Bill C-36 is to protect women and girls. And of course, we know there's many, many more people working in the sex industry other than cis women. So like, do those people deserve protection? I don't know. So of course they do, right? If they're being exploited, but the government's clear focus is on women being exploited regardless of their own feelings about whether or not they're being exploited.
Yeah, that should be fairly simple to establish, you would think.
No, this has been super interesting. The obvious ending comment is have fun learning and browsing OnlyFans, Deanna.
We don't know whether or not it's legal.
Yes, exactly. Advice taken.
If you run into trouble.
Yeah, that's right. I might be coming to you for some